My name is Heidi Kummer. I'm the current president of the Patient Advocate Certification Board. And one of the fun things I get to do during this conference is introduce one of the speakers, and in this case, a good friend and fellow BCPA, Michelle Riddle. With several years of healthcare experience, Michelle Riddle founded Complete Dignity Healthcare Advocacy based in Phoenix, Arizona in 2015. Complete Dignity Healthcare Advocacy is a nationwide health advocacy company providing services to the consumer, employer, provider, and self-funded markets. Michelle is committed to meeting the needs of patients and their family members, collaborating, matching resources, and using her experiences. Michelle is dedicated to taking the confusion out of the healthcare system to improve the quality of care containing healthcare costs. Michelle achieves results by auditing medical bills for errors, coordinating care among providers, negotiating medical bills for payment, solving insurance reimbursement issues, managing the navigation of care, and obtaining aid and assistance, for instance, finding the best pricing on prescriptions and medical services. Today, Michelle will talk to us about legislation and advocacy, which I know is a scary topic for many advocates, but incredibly, incredibly important. So thank you, and take it away.
Thank you, Heidi. Okay, I kind of feel like put baby in the corner, so I'm gonna walk out, and I got a clicker. So if you're having a hard time hearing me, or you have a question or whatever, just raise your hand, and I'll move back to the corner. So again, my name is Michelle Riddle. I'm with Complete Dignity Healthcare Advocacy. Like Heidi said, I founded Complete Dignity in 2015. Legislation is a huge passion of mine, and the reason why is because legislation protects patients' rights and wins cases. So if you're struggling with a case and they don't want to budge, you present them with facts, and facts wins cases. So let's go ahead and get started. Okay, so protecting patients' rights and their pocketbook, they basically go hand in hand. Financially, we've got number one reason for bankruptcy in our country is medical debt. Okay, so the cost of care is astronomical. It's unfortunately there has been changes, but it wasn't transparent. So you had no idea what the cost of the care that you were going to receive was going to impact your life. Okay, so we've got federal and state transparency laws. To date, 33 states have passed laws that encourage. That's the key word, encourage. So it's not mandated, it's encouraged, which that basically means we still have work to do, okay? Cost transparency, and these are the states in green that actually have transparency laws on their books, okay? It is so important, like I just said before, to know the cost of care before you receive care, okay? And to be transparent, to understand if you've got an insurance policy and you've got a deductible, you have an out-of-pocket max, you have a cost-sharing portion of your plan, you know what your boundaries are. But if you don't have that, okay, if you don't have an out-of-pocket max, because there's lots of plans out there that have a deductible, but then there's no out-of-pocket max. So if it's like a 70-30 split, you're on for 30%. Forever, because there's not a max. So you need to know what your financial responsibility is in your care. Okay, healthcare transparency, supportive states. Okay, early mandates. This picture right here is actually where I'm from, San Diego, California. This is Del Mar. So I was pretty excited when I did my research that I found that since the early 2000s, California licensed hospitals to have required annual, they have to annually submit to the state for public posting their charge master, so their charge description. The charge master, I'm going to go on. The charge master is a comprehensive list of billable to hospital patient and or patient's health insurance providers. Hospitals use their charge master prices to negotiate reimbursement rates with private payers. Consequently, hospitals tend to set their charge master prices to remain competitive and negotiate higher rates from private payers. As a result, the prices are usually significantly higher than actual cost of care. How many times have you received a bill or you've seen your patient's medical statement and the cost of care is astronomical? You're like, how did they come up with that number? And that's the reason for it. So I like to call it funny money. It's monopoly money. It doesn't, so you've got a contracted rate with an insurance company, they're only gonna pay that much. And then if your deductible is not met, your out-of-pocket's not met, then the hospital's gonna get more, that provider's gonna get more. So there's still this funny money floating around that nobody claims. So it's really, really important to have the true cost of care and the transparency with the true cost of care and not this funny money amount that they can, use to negotiate with the payers and within their contracts. Okay, as a patient advocate, it is really important to understand how medical items and procedures are billed. Charges can be negotiated, they always can be negotiated. So that's one of my jobs. I do provider fee negotiations. If a patient comes to me and says, I've tried, they will give me like 10% off or they won't do this, and they're threatened to take me to collections and they won't negotiate and that I have no rights. Well, guess what? You do have rights. You absolutely have rights and everything is negotiable. You just got to get to the right person, okay? Keeping errors in check. 80% of medical bills in our country consist of some sort of errors. 80%, guys. Whether they're clerical errors, whether they're intentional errors, but they actually exist. Okay, healthcare compliance requires observing medical coding, regulations, guidelines, and state and federal laws. I'm going to go over a list of laws that are really beneficial for advocates to know and to utilize to protect their patients. The False Claims Act, the Lincoln Law, federal law that imposes liability on persons and companies who defraud governmental programs. In Arizona and in Colorado, we have a very large provider that how do I say this? They falsified their claims and submitted their claims to Medicare and Medicaid, okay? That's False Claims Act. And they ended up having to pay over $18 million back to the government. So when you think of a provider that is intentionally submitting claims and breaking this law, wouldn't you think that it's time to shut their doors? Wouldn't you think that there's got to be consequences to their actions? And unfortunately, it's just pay this fine and go about your business until somebody else comes along. So it was actually a nurse who was a whistleblower, and she blew the whistle on this facility, and kudos to her. I will tell you that this nurse is actually a professional whistleblower, and if a provider does the research and looks at the references of this individual that they're about to hire, they better make sure that it's not the whistleblower if they're doing something illegal. So I think, I think it's fantastic because we have to be patients' whistleblowers. If we see something not right, you need to look into it. You need to investigate it, because if we are not our patients' voices, in my professional and personal opinion, we're not being that patient's advocate. Okay. All right. Emergency Medical Treatment Active Labor Act to ensure public access to emergency services regardless of the ability to pay. We all know that if you go into an emergency room, if you don't have the ability to pay, services are going to be provided for you. There's so many countries around the world, if you don't show proof of payment prior to receive services rendered, they're not going to treat you. So this is kind of like a double-edged sword, where you don't want to take advantage of the situation. You want to be prepared to pay, or you want to utilize the financial assistance that we have. Now, I will tell you that there's many facilities, and I utilize these laws and their assistance program for my patients all the time, that the way that it's structured for a nonprofit organization, they have to offer financial assistance. However, they have the ability to come up with the definition of who qualifies for these financial assistance. So there was one provider, a very large provider, who their qualification was, if you have insurance, it doesn't matter what kind of insurance, but if you have it, you automatically disqualify for any financial service. So it doesn't matter if you've got debt, if you've got this, you've got 10 kids, and you've got it doesn't matter. If you have insurance, you're automatically disqualified. Now, they have recently changed, and I think it's because the squeaky wheel gets oiled, guys. You have to communicate to the CFO, the CEO. They have to know your name. They have to know your base, because they will make the changes. Okay? All right. Next is physician self-referral law, the Stark Law. Prohibits physicians from referring patients to receive designated health services payable by Medicare or Medicaid from entities with which the physician or an immediate family member has a financial relationship, unless exception applies. I've got a case right now where the patient required a procedure, and she went to an in-network provider, and the physician said, okay, I want you, let's go over to this outpatient surgery center, and we'll take it, I have the ability to perform surgery there, and so forth. And anyhow, when she went in, she's in a lot of pain, and she's under medication, so she really doesn't have her faculties about her because she's in a lot of pain. She's medicated, so she's signing all these documents. She's like, okay, I got to get back. Let's get this done. And the doctor owns part of that facility, okay? That happens a lot. So one of those documents that she signed was basically informing her that, hey, I receive financial gains from bringing you to this facility. But what the doctor didn't state to her is that this is outpatient, or I'm sorry, that this is out of network. So her insurance company kicked it out. And then what did they do? They balance billed her. And I'll go into more about that in just a little bit. And it was, and we're still in the midst of it. We're still going back and forth. But was it truly informed consent? No, it wasn't. It was not informed consent. And especially being medicated, under distress, she's in a ton of pain, she just wants it done, let's get the show on the road type. Okay, so that kind of leads into the anti-kickback statute, criminal statute that prohibits exchange or offer to exchange anything of value in the effort to induce or reward the referral of business reimbursable by federal health care. So one of the things that, as a BCPA, referral fees, non-existent, okay? That is not, we do not take referral fees. We are private pay. And it's, if I'm gonna refer someone to, it's not really a referral. If I'm going to inform my patients, this doctor, this facility or this group home or this assist, here's the information. I'm here to inform you of what your options are. So there's no referral. So keep that in mind. If you are a BCPA, you are not to accept any type of referral fee. That is conflict of interest, code of ethics. It's really, really important to keep that in mind. Okay, HIPAA, privacy, and security. I hope everybody in this room knows everything about that, so I won't go into that. And then the Occupational Safety Health Administration, OSHA. Let's see. Okay, healthcare transparency, executive order was signed by President Trump in September 24th, 2020. The goal of this transparency is ensuring access to health insurance coverage for consumers with pre-existing conditions. When that was brought to my attention, I thought, gosh, we already have something like that in place. So I'm not real excited about that because there's already a safety net surrounding that. So expanding hospital price transparency, I am super excited about that. That needs to be done. We need to know what is the true cost of services. And then limiting medical surprise billing. That is another thing. Again, going back, number one reason for bankruptcy in our country is medical debt. We need to take care of this. Okay, January 1st, 2021, hospital price transparency, CMS 9915F, No Surprise Act. That was passed, it became active. United States hospital reimbursements, this is what they're supposed to do. Display shoppable prices in a consumer-friendly format, in a comprehensive machine-readable file with all items and services. That, if they put it into, if they don't alphabetize it, and if they stick it in this spreadsheet that's full of all this information, and no one's going to be able to read that, they're not going to be able to follow it. Now, if it's alphabetical and it's by conditions, then we can follow it. But most likely they're not going to put it in there. And I don't know if you've all actually gone on hospital websites and looked at the cost. It's like procedures like, what procedure's that? It's not your typical procedures that are happening, and which is fine, but you're looking for the procedure and you can't find it. So I'm hoping that this is going to clean this up. Okay, final rule compliance. I got a little smiley face here because it makes me laugh. So 65, which I think is low, 65 of the nation's 100 largest hospitals are non-compliant. Not low, I think it needs to be higher because I just don't feel like compliancy is a real thing with these hospitals. I don't feel like they're compliant. COVID-19, a barrier in compliance, yeah, I do feel that it's a struggle for the past 2 years. It has kind of derailed a lot of our, our process, the facilities, how we conduct healthcare, how we conduct business. So yes, I do feel that is a barrier. There's two comments that two VPs of hospitals, this was their comment. Hospital VP stated, the machine-readable part of the rule, I hope that goes away. I hope CMS realize that hospitals are already helping patients understand prices and that the machine-readable side isn't necessary. Really? I don't think so. No, they're not communicating with you. How many times do they come in and say, this is what it's going to cost? You have no idea. You end up with a surprise bill. Or they come to you and say, look, we're not going to do this outpatient procedure until you give me 10 grand. Wait a second, did you process it? Did you submit my claim to insurance? Did you do this? How do you know I owe you $10,000? So that's a level of transparency. Another executive states, one interpretation is simply publish your rate schedule, whatever your rate exhibits are in your contracts, publish that and that's compliant. Another one is to summarize the CMS packages and what your negotiated charges are by package. You start going down that path and it gets, very confusing very quickly. If we knew the contract between the carrier and the facility and the provider, do you know how great that would be? I mean, it would be fantastic. And the other part about, how about the facility and the provider? What about that contract? I'm going to give you an example. This was a long time ago. I had a patient in the hospital. She had surgery, and her surgeon, they all send their separate bills, right? So the surgeon sent her bill, and it was over $13,000. And she didn't have insurance. She had no idea, everything was like astronomical. So I contacted the surgeon's office, and I said, okay, so what's your stipend? And she goes, what? What do you mean my stipend? Well, what's your contract between the hospital and your provider? So we need to deduct that stipend from the patient's financial responsibility, and then then we'll discuss if we need to negotiate further. And she's like, oh, okay. So she's like, give me 30 days. I'm like, all right, because everything is like 30 days. So I gave her 30 days, reached back out, and I said, did you figure out what the stipend was? And she goes, yeah. And I said, okay, what's my patient's financial responsibility? She goes, $95. So right there tells you, if I didn't ask that question, that patient could have been on the hook for $13,000 when she really only owed $95. So it's like double dipping. They're getting paid. So to know that transparency, to know what the contract is, to know what the cost is crucial to a patient's rights, to a patient's pocketbook. Okay, so, and then here's a thought. How about publicizing a contract between the treating provider and the hospital? Okay, non-motivating, non-compliance penalties. The maximum penalty for a hospital who fail to comply with the rule is $300 per hospital per day, or $109,500 per hospital per year. Really? Do you think that's going to make a big difference to them? They're going to be like, okay, just pay that. That's not a huge amount of money. That's not going to make them to be compliant. CMS has reserved the right to revisit the amount of the civil penalty. CMS is not enforcing hospitals to abide by the final rule. However, individual complaints come in, the hospital is warned of the complaint, and CMS intends to publicize these notices imposition of civil monetary penalties on the CMS website. If they do that, I do feel, because the hospitals don't like to get dinged, they don't like to have negative press. So if they really push this, and if they're really on top of it, I think, but the whole part of this is that the patient has to reach out and has to submit a claim. Has to submit, or not a claim, a complaint. But if that part isn't done, the hospital's gonna get away with it. So again, with advocacy, you're now gonna be educated in this realm. You can, God bless you, you can inform your patients, hey, we could take it to this level. Is it gonna do anything for you right now? Probably not, but it's gonna make a difference in the future, okay? The CMS new price transparency rule has survived legal challenges on both the district court and the appeals court. Compliance remains final hurdle. So that is the hurdle, is being compliant. So the judges, the courts, they totally agree with it, but it's the compliance. So we need to make more noise to make sure that that compliance is actually withheld. Okay. Okay, should I or shouldn't I? It's estimated more than 56 American citizens say that the healthcare costs have led to sacrificing in the delay or skipping care, dealing with pain, or doing without medications. We all know that. We all know that patients need medications, patients need a procedure, but because of the cost, they're not doing it. And then guess what? Their challenges or their situation with that condition has just increased. And now what's gonna happen? So it's all about, like the elder law attorney that just presented, follow the money. Follow the money. The money is the key. Okay, fellow law. This you probably have never heard of. A law that holds adult children financially responsible for their parents' medical care expenses when parents are unable to pay. Y'all, this is a real law, okay? And it's actually scary. Let's just say, I'm gonna paint a scenario. That's my mom. I haven't seen my mom in 25 years, and I don't like her. And she was a horrible mom, and da-da-da. But you're the child. So if that state has a federal law in place and they enforce it, they can come after you for that, for whatever medical expenses your parent has, okay? The need for elder care is growing. The outcome of litigation between children and of the elderly and nursing homes caring for these parents depends on each state's federal law. If you live in a state that has a federal law, your responsibility guidelines, it's important to understand when those laws can be applied. For instance, it's possible that the nursing home providing care to one or both parents could come after adult children personally and collect on any outstanding bills owed. Here are the states. Okay, so the states in white, they do not have federal laws. The states that are in like a yellowy color, browny yellow, they do, but they're not active, but they have them. So if they want to, they can enforce it. So you need to be aware of that. The ones, there's 4 states that actually enforce it, and those are South Dakota, Pennsylvania, Puerto Rico, and Rhode Island. They do enforce them, okay? Yes?
Would that apply if the child didn't live in that state? So if the parent lived in South Dakota and the kid lived in Illinois, could South Dakota come after the child in Illinois?
So that's a great question, and my recommendation is to contact an attorney in your state and make sure, because the way that the federal law is written per state is different. It just means that they have the ability to come after the child to pay for the medical expenses, okay? So know your state laws. So this whole presentation is just to make you aware of what's out there, but take ownership of your state and know these laws and how does it apply to your residents in your state. Okay, COVID relief. In the background there, it's a dry desert. Federal funding for COVID-19 testing and treatment of uninsured Americans has dried up. There's no more money, okay? Health Services and Resources Administration also announced coverage for COVID-19 vaccines for uninsured are no longer available after April 5th of 2022. As of January 1st, most insurance companies are now applying what's called your cost sharing. That's your deductible, that's your out-of-pocket expense. So know that there's a financial responsibility. I know that during the pandemic, and even now, there's, we're, getting tested, we're going to the doctor because there's a level of fear that has affected all of us. And now where before we'd go and get tested and it wasn't an out-of-pocket expense. But now it is. It's going to go toward your deductible. Or if you don't have insurance, it's going to be out of pocket. Okay, COVID laws, public readiness. Yes.
That slide you just came off of. I know that currently they're asking for additional funding for COVID. So if they get the additional funding that they're asking for, wouldn't those two bullets, is there a chance that those two bullets would then mean that the people who are on the hook now for coverage will no longer be on the hook because they can send it back through?
That's a great question, but I mean, honestly, I have no idea. I have no idea is it going to be retroactive, or is it's just people moving forward? So I think it's a question that has to be determined after they've granted more funds. Okay. Okay, COVID laws, Public Readiness, Emergency Preparedness Act. The courts have characterized the PrEP Act immunity as sweeping. It applies to all types of legal claims under the state and federal law. For example, under state tort law, individuals who suffer injuries caused by intentional or neglect acts or omissions of another person may generally sue that person to recover monetary compensation. However, federal laws, such as the PrEP Act, may preempt state tort laws, as well as other state, federal laws in certain contexts, the PrEP Act. So real quick on this, with the situation with our pandemic and the PrEP Act, and also state provisions. So when COVID came into play, states took it upon themselves, which they should, to protect because of a state of emergency. So to protect the healthcare providers, to protect the employers, to protect. So it was kind of like a blanket provision that protected everyone. But what as an advocate, what I've come across is that blanket statement, there's been a lack of care. And so they're showing good faith that they are doing what they're supposed to be doing, but they're not doing it to the caliber that they need to be doing it to. But there's no, I've got multiple cases that I work with attorneys, and they're protected. So is that going to change? Yeah, it's going to change, but it's because we're in the state of emergency that we had to put in place these provisions to allow people to get treatment, to allow people to treat, so it was to keep the process going and not bottleneck it. Okay, so the Right to Try Act, going back to COVID. It's apparent with new COVID variants, we will be living with COVID for a long time. May 30th, 2018, the Right to Try Act was signed into law by our 45th President of the United States. Federally, it was signed. Right to Try opens a new pathway for terminally ill patients who have exhausted their approved options and no suitable clinical trials exist. Oops, hold on. Okay, Right to Try. To be eligible for the Right to Try, this is really, really important because I think, especially during the COVID, there was a lot of discussion surrounding the Right to Try. So, but there's provisions surrounding that Right to Try, and you have to abide by those provisions. There's guidelines. And to be eligible for the Right to Try, a patient must be diagnosed with a life-threatening disease or condition, have exhausted approved treatment options, be unable to participate in a clinical trial. This is key, requires a treating physician's approval. So if you don't have the approval of that treating physician, you can't utilize the Right to Try. So you have to have approval. Give written informed consent. Right to Try only applies to treatments that have been completed an FDA-approved phase 1 clinical trial and remain under study in an active clinical trial. So let me go back. So with the COVID situation, I utilize, yes?
On the last point, can you just clarify, does it have to be an FDA-approved phase 1 trial for that particular indication? So, for instance, I have a client with Merkel cell, and we don't have a lot of treatments there. We would like to avail him of a drug that has passed through phase 1, but is not, has had no studies for his particular type of cancer. So does it have to be phase 1 for that particular indication, or just phase 1 period? We don't care whether they were going after, you know, brain cancer, colorectal cancer, ovarian cancer.
Yeah, great question. So it states that it has to have gone through the phase 1 concerning that situation, and it has to remain in some sort of a clinical study. So I can't say definite, but how it's written, it seems that you do have to follow those guidelines. Okay. So the right to try in COVID, recently I had a COVID patient, 56 years old, extremely healthy, ran every day, ended up with COVID. He's in the ICU. His lungs, they were like cardboard Swiss cheese. I mean, he had less than 30% chance of survival. And he was on a vent. Basically, I researched all options and brought options to the family. And the family's like, let's see if the doctor agrees with anything, or maybe he has options, like what else can we do? Because it was more of just kind of waiting and seeing. Here's the protocol. We're gonna stick with this protocol. We're gonna wait and see how he does. And the family wanted to be proactive, and they wanted to utilize the right to try. So I brought 7 options to the CARE conference, and the treating physicians accepted 5 of those options. So we got treating physicians approval. So that's number 1. It was in the phase 1, so that's number 2. So they utilized 5 of the options. I'm happy to say that the individual's at home. He's living independently. He's not on oxygen. Yeah, he does have, some lung challenges, but every day he's getting better and better. But we utilized the right to try. So that was crucial. Okay, Arizona is the first state to implement the right to try. And being from Arizona, I'm super happy. Yeah. So super exciting. Like I said before, we've got a federal law right to try, but Arizona now, was the original right to try state. Not only Arizona is the first state to implement the right to try, lobbyist Goldwater Institute pursuing the addition growth to the already enforced right to try law by putting another layer of options to an individual patient based on the patient's unique genetic sequence and those mutations that are causing their disease. So this picture right here is, maybe a month ago that I testified in front of the House of Representatives. And I testified for SB 1163. And this is it's for individualized right to try. What works with that person's DNA? And I'm happy to announce that the 25th of this month, it was passed. So now Arizona is now #1 again. So super exciting. There's options, guys. As advocates, it is our jobs to come up with options. What are your options? What can we do? Let's not, go, oh gosh, all right, we've tried this and this and that's it. There's gotta be something else. There's gotta be. That's why you're here. That's why you're hired. You're hired because they have hope. You need to take that hope and you need to run with it. And you need to look under every stone, look anywhere and everywhere, and give them that information and let them decide if they want to do anything, okay? 41 states and counting already have the right to try laws in place. Okay, No Surprise Act, balance billing. No Surprise Act is a federal law that took effect January 1st, 2022 to protect consumers from most instances of surprise billing, and legislation included the Consolidated Appropriations Act 2021, which was signed into law by President Trump in December 2020 after receiving strong bipartisan support. We come together. It affects us all. I know that at the beginning, one of the attendees was talking about, or no, it was the panel, was talking about, what side of the aisle are you on? I don't care. We're all together. We all need to come together and collaborate and make sure that patients' rights are being heard and that we're doing everything that we possibly can. Biden administration spent much of 2021 working on the implementation of new law. Interim final regulations were published in July 2021 and October of 2021. So September 21, it became active. Well, it was finalized and then became active January 1st, 2022. Okay. No Surprise Act, I want to make sure, sometimes I get a little chatty. No Surprise Act, balance billing, bans surprise bills for most emergency services, even if a provider by an out-of-network provider without approval. So no prior authorization was attained. There's already safeguards in place for that, so that really, we've got the gap exception, so there's already safeguards. So I wasn't really impressed with that too much. Bans out-of-network cost sharing, like out-of-network co-insurance, co-payments for most emergencies and some non-emergency services. You can't be charged more than an in-network cost sharing of these services, okay? That's great, but like I said, there's already protections in place for that. Bans out-of-network charges of balance bills for certain additional services like anesthesiology, radiology, furnished by out-of-network providers as a part. We've already had that in place. Requires healthcare providers, facilities provide written notification informed consent of being balance billed by an out-of-network provider. That's key, informed consent. I think, I really feel that patients are not informed of what their rights are. They're not informed of what they're signing. There's a million, pages that they're signing. Or how about when you go into a hospital and it's digital? Okay, so they got the little signature pad that's about this big. And the patient, they're like, oh, it's just initial here, and you have no idea what you're signing. And the patient's under distress, and so this is where the No Surprise Act, it's going to be challenged. It's going to be challenged because the facilities and the providers, they're implementing these informed consents, but they're really not, the patients aren't really being informed, okay? The other part of the No Surprise Act, which there wasn't safeguards in place, was individuals that were not insured. Now there is a protection for individuals that are not insured. If you go in for a facility, or you go in for a procedure, and they give you the good faith estimate, if it's over $400 above that good faith estimate, you have the right to challenge it. So, or if they're within that, good faith estimate, then you're not being balance billed. But if it's over, and $400 is really not that much, right? Especially in the scheme of healthcare. So now uninsured, they're protected. I'll give you an example. A patient of mine, uninsured, went into the ER. She had a procedure done, and she came home. She received her medical bill, and it was over $157,000 because she had no insurance. So it was that funny money, right? It's monopoly money. So I negotiated that with the CFO, and I got it down to $3,800. That tells you where's the, you know, it's like it's a fluid. It's a moving target, and it doesn't make any sense. But if that patient didn't have an advocate on her side, she would have been in debt to that facility forever. 150, that's someone's house, you know? So that it's, am I going over? No, keep going. Okay, certified independent dispute resolution entities, they have, so with this new law, there is this department, so you submit your complaint, however, there's a fee, okay? So it's not, I mean, they're on your side, but there's a fee. What happens if the patient doesn't have the money to pay for that fee? So then their credit, you know, they just don't pay, and then the debt goes to collections, and then it ruins their credit report, and, you know, it's just this vicious cycle. Okay, informed consent, like I said, Code of Ethics, Opinion 2.1.1, informed consent concerning medical treatment, fundamental in both ethics and law. Again, it is really, really important for patients to be aware of what they're signing, what procedure, and what is the financial responsibility. And what does that look like? Because that financial responsibility, again, is fluid. So if they give you a good faith estimate and it's over that $400, even if they're insured or uninsured, that's still balance billing. Okay, enforcing compliance governmental agencies. State Department of Insurance. Every state has a State Department of Insurance. And if you've not befriended them and become besties with them, you need to, because they're the ones that are going to help you with your insurance. So if you've been denied services and you've appealed it, and I will tell you this, I can't tell you how many patients have reached out to me. Typically with your insurance, you have 2 internal appeals and you have 1 external appeal. So, and after that external appeal, the decision is final. You can't go back. So that's it. If the first appeal was denied and then you write the second appeal and then you go to external appeal, your external appeal is actually done in the State Department of Insurance. So they're completely separate. They're not a part of your insurance organization. They're not employed by them. But I will tell you that patients, they submit their appeal, and it's solely based on emotions, which it should be. But that doesn't win an appeal. It is facts. Facts win appeals. And if you, and this is where that legislation and advocacy comes in, you have to state legislative statutes. You have to state that information in order to prove to that carrier, you know what you're talking about. And if you don't reverse this appeal and approve it, then you're in breach of contract. So it's really important to know, you know, the ins and outs of appeals, or if you don't know, you need to find an advocate who does, okay? So State Department of Insurance, they're fantastic. Department of Labor, oh, this one's a tough one. So I had a case who, it was a child, and he needed a procedure that was not available in the state of Arizona, and we had to get him to California to get this procedure done. Great insurance, but it was a self-funded plan, okay? So self-funded plans are protected by the ERISA Act, okay? And they're protected by the Department of Labor. And so the State Department of Insurance, they have no jurisdiction. They can't help in the case. And so the patient went and had the procedure. The family paid out of pocket and expected reimbursement from the carrier. And unfortunately, their reimbursement was, their out-of-pocket expense was over $65,000. Their reimbursement was like $6,500. I can't remember off the top of my head, but it wasn't even close to what they had paid. And so I submitted the appeals. I submitted the statutes. But guess what? Self-funded plan. They can make up their own minds. They can make up their own decisions. They're not really that afraid. They're really not afraid. So it was denied. It was denied a second time. Then I requested a external appeal, and they denied the external appeal because they said didn't meet qualifications. But they could because they're a self-funded plan. So then I reached out to Department of Labor, and you have to put a report together, a full report of everything. And you have to basically, they have to approve your complaint before they bring it to the employer. So I had to prove my case to the Department of Labor, which they're like, oh yeah, okay, all right, with all the documentation. I mean, it was a full report. It gets submitted to the employer, and the employer says, no, we're gonna hold our denial. It's not gonna, well, guess what? It's in litigation right now. Because they can. So, but what I'm trying, and as advocates should try to do, is prevent it from going to litigation. So if you have knowledge of the laws and how to protect a patient, then you're protecting that patient's pocketbook. Because they're gonna pay for you, but do we really need to pay for an attorney on top of it? Unfortunately, with this situation, we did. However, I mean, it worked out and everything is fine, but I really did not want it to go to that next level. Unfortunately, with the ERISA Act, sometimes you have to. Okay. So, and then Department of Health and Human Services for self-insured plans sponsored by non-federal public employers. The U.S. Department of Health and Human Services has primary enforcement authority. For federal employees, health benefits, enforcement authorities rest with the U.S. Office of Personnel Management, OPM. Okay, airline, is someone timing me? Because you are, I'm good? Okay. Oh, okay. All right, Airline Deregulation Act of 1978. This one I've utilized, well, the law protects medevac. This act actually protects medevac companies. So they're typically not in contract with anybody, and they can charge whatever because they're under the Airline Deregulation Act of 1978. I had a case that patient, young couple, they just had their baby, they just got their brand new home. It was a new development, so there was a bunch of empty lots, and the husband takes out his dirt bike, and he's gonna go ride in these, vacant lots, and he's gonna have a ton of fun. He wasn't being crazy or reckless or anything, but he hit a curb, and he went over, and he hit his head. And so he was medevaced, and he died. And so then I got put on the case to make sure that insurance covered what they were supposed to cover, and his medevac bill was over $59,000. It was less than 10 miles of drive, okay? And we fought, and this was a self-funded plan. So this self-funded plan was based in, I can't remember what state, but it was based in another state, and they had a ex-senator of another state who's an attorney. He was the negotiator, and this attorney didn't want anything to do with me. He would not communicate with me. He didn't, but we ended up winning, and my the widow didn't have to pay a dime. But you have to know the law, and you have to know who to go through and how to protect that patient's pocketbook. Okay, single case agreement. So single case agreement prior to services, get it in writing. Make sure that that if they say, oh, this is only going to cost $5,000, okay, that's fantastic. I agree to that. I need it in writing. Don't take their word, because I can't tell you how many times they're like, no, we didn't say that. No, we didn't say that. Get it in writing and hold on to it. Okay. Okay, nonprofit facilities. The majority of hospitals in the U.S. operate nonprofit. They are tax exempt. And like I said before, under the Affordable Care Act, nonprofit hospitals are required to offer patient assistance programs. However, they are able to lay out the guidelines and state who they're going to give that financial assistance to. Federally, they don't tell them how they're going to lay it out. It's facility by facility. Okay, patient bill of rights. Be fully informed in advance about the services and care that to be provided. Decline participation, revoke consent, disenroll at any point in time in a patient management program and services. Last weekend, I had a call, a frantic call. I typically don't take calls over the weekend. I try to make sure that my personal time, I reset my batteries, and then I start again on Monday. But this call kept on coming in, and I was like, all right, and so I listened to the message, and I was like, ooh, okay. So I reached out, and it was an acute facility, and the family was hysterical because the facility was holding their loved one against their will. So the patient bill of rights, you have the right to decline participation. You have the right to say, hey, I'm out, I'm going home. Well, this facility, older gentleman in his wheelchair, trying to wheel himself out the front door. They took the wheelchair, they took him behind TBI and into a locked ward and kept him there. And the treating physician said, you'll leave when I say it's ready. I say you're ready. And so I was like, oh, no, they can't do that. And so I walked in and I introduced myself. You introduce yourself, you're super polite, kill him with kindness. And I said, hey, I hear that this happened and he's in the locked ward and he doesn't want to be here and he's ready to go home. And he has all of his faculties. He's totally, coherent. And the CEO kind of she took a step back and she goes, oh, you're absolutely right. Okay. And then director of nursing and everybody came in. I had this big old care conference, and that was Monday first thing. And by Tuesday, that patient was home. And that facility was not going to release my patient. And that's not okay. So educating patients that they have rights. If I had another patient who was in renal failure and he didn't want comfort care. He didn't want food or drink. He didn't want anything. He just wanted to pass away. He wanted to have his dignity and pass away. And the hospice provider was very adamant about giving him nutrition, giving him his medication, and so the POA hired me and said, could you make sure that his wishes were written out. So it's a legal binding document, right? So they were written out, but they still, it was humane to them, so they had to do what they had to do. And I said, it's his wishes, it's not mine. When I'm in hospice care, you better give me everything. I want McDonald's, I want the meds, I want everything. So, but those are my wishes. And so when I introduced myself and I had a care conference with that team, I said, okay, can you introduce me to the patient? And they said, he's not coherent, he has a bed sheet over him, he doesn't, he just has his undergarments on, he's not paying attention. He has no idea. And I go, that's okay, I need to go in and introduce myself. So I went in, introduced myself, and I told him what my job was and what I was gonna do. And as we were all walking out of his room, he says, "Thank you." And I turned to the team and I said, "Don't ever think a patient can't hear you, because they can hear you." So giving them their dignity and abiding by their rights and their wishes is number one. It's critical. Okay, in conclusion, facts win cases, guys. Know your facts, know your laws, and not emotions. I can't tell you how many times I've been in situations where I am doing double swallow, to hold everything back, because they didn't hire me to be emotional. They need to be emotional. They hired me to be their voice so that their choices are heard. So keep your emotions in check and know the facts. Know your limitations. If this is above your ability, delegate. We have an army of advocates. Delegate. Find who that is in their wheelhouse. And then always, again, search for facts. Everything surrounding a patient's care, healthcare crisis is unfortunate, emotional, and horrible, but know your job and facilitate a favorable outcome. That is your job, that favorable outcome. Small stuff does matter. Everything you do, it does matter. It makes a difference in someone else's life. Thank you. Questions?